This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Okay, good. One last time. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner to eliminate all conflict and false allegations. Is there anyone in tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, province, country, county, city, township, agency present? This is also for notary, poll workers, school board members, anyone who signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Looks like we're all clear, and I'll open up our talk with a short prayer. O Holy Father, bless our meeting with eyes to see and ears to hear the messages and information being presented with an open and caring and compassionate heart for our fellow brothers and sisters, as it shall be done. Take it away, Glenn.
All right. What's that buzzing sound I keep hearing?
Well, that's somebody posting in our group, and because I have the notifications muted, it buzzes me. So,
that's bizarre. I've never had that before.
I'll mute out now. You won't hear it.
Okay. Well, this is a habeas corpus. This is a petition for writ of habeas corpus. These are arguments that you can bring up. And I would highly recommend you can use this, and certainly in Texas, any of the southern states, in California, any states covered by the Treaty of Hidalgo. You can use this anywhere there. And after that, it gets kind of murky. As to whether you can use it or not. You have to be able to show that you're under martial law. But you can certainly use it anywhere in the southern states, Civil War states, or Treaty of Hidalgo, which would be California, Arizona, New Mexico, Utah, and Nevada. I'm not sure about anything beyond there. Maybe parts of Colorado, I'm not sure. Anyways, so I have sanitized this. I use interveners. I'm telling you, this is, a lot of times when people have a lawyer, it's you can sit there and file stuff in there and they just ignore it. But I can tell you that I have filed stuff as interveners and they don't ignore it. Tell you, it's kind of interesting to see their reaction because it's. But so I would say file as an intervener, notice of intervention, and I can show that here in a minute what I filed, and that's it. You're intervening on somebody's behalf, and actually I would change mine a little bit, and I'd say as a friend of the court, because you're interested in justice, is you're presenting some more stuff that the court needs to consider. In the interest of justice, anyways. So this one here is a friend that I'm helping, and I filed a notice of intervention. And this is an application, okay? This is in Texas. These are, there's a friend of ours that has successfully gotten people out of jail with habeas corpuses, but they did applications, okay? So we're going to call it an application in this case. And you actually file it. If you do it in federal court, then you don't give them a case number. You file a new case, a brand new case, and then you have to explain, what everything, where the case is, and who the sheriff is that's got custody and all that. But this is filed into the actual case, and so you're bringing up issues that And there's people that I know that have done it and have done it successfully, and it's been done this way. So, anyways, so the person is currently incarcerated in Tarrant County Jail, 100 North Lamar Street, Fort Worth, Texas, awaiting trial for 2 counts of burglary of habitation, indictment numbers, Texas Penal Code, and the 45th District Court, Tarrant County, Texas. And so President Andrew Jackson officially recognized the Republic of Texas on March 3rd, 1837, which is also recognized by France December, excuse me, December 25th, 1839, and other nations, including Belgium and the United Kingdom. The state of Texas joined the Confederacy and Union. In the year 1845, the state of Texas joined the Confederacy and Union under the Articles of Confederation and Perpetual Union, 1781, as evidenced by the Act of Congress 9 Stat 1, and still exists as evidenced by House Joint Resolution 1, dated 29 December 1845. The territory properly included within and rightfully belonging to the Republic of Texas was erected into a new state to be called the state of Texas, on an equal footing with the original states in all respects whatever. Okay, so when they're talking about the original states, they're talking about the Articles of Confederation. With the Republican form of government as found in the Act of Congress, December 29, 1845, at 9 Stat 1. This is the preamble to the act, and this is Texas's hereby. The laws of the United States are hereby declared to extend to and over and have full force and effect within the state of Texas, admitted at the present session of Congress into the Confederacy and Union. And in House Joint Resolution 1, dated 29 December 1845, by joint resolution approved March the 1st, 1845, did consent that the territory properly included within and rightfully belonging to the Republic of Texas might be erected into a new state to be called the state of Texas. So they created a state of Texas as an overlay and admitted into the Union on an equal footing with the original states in all respects whatever. Normally, when one sovereign nation joins another sovereign nation, a treaty of annexation is approved and adopted. A proposed treaty of annexation was prepared by the Republic of Texas and sent to the U.S. Senate for approval and adoption, which was not approved or adopted but shelved. The state of Texas was created under Articles of Confederation and Perpetual Union, 1781, under Article 9. But no other colony shall be admitted into the same unless such admission be agreed to by 9 states, right? So it takes a House Joint Resolution, which means a House Joint Resolution is all that's needed. Therefore, the state of Texas is a fictitious overlay over the Republic of Texas, the territory properly included within and rightfully belonging to the Republic of Texas, which means the Republic of Texas was not replaced by the state of Texas, and the Republic of Texas still existed in abeyance or dormancy. For the state of Texas to join the Confederacy under the Articles of Confederation and Perpetual Union with a House Joint Resolution is perfectly fine, but the preamble of the Act of Congress, December 29, 1845, says Texas was admitted to the Confederacy and Union of the United States, which is also talking about the Union under the current Constitution, which was in place in 1845. And Article 4, Section 3, Clause 1, requires, but no new state shall be formed or erected within the jurisdiction of any other state, which is what was done. The territory properly included within and rightfully belonged to the Republic of Texas was erected into a new state to be called the state of Texas, on an equal footing with the original states in all respects whatever. So that's what they did. So I think that's unconstitutional. Matter of fact, that's actually an issue that I'm bringing to the U.S. Court of Appeals for the Fifth Circuit right now. The state of Texas failed to replace the Republic of Texas, and the Republic of Texas that was recognized by Andrew Jackson still exists, and recognition is unconditional and irrevocable under Article 6 of the 1933 Montevideo Convention on the Rights and Duties of States. that was acceded to by the U.S. Senate as a treaty and entered into force December 26, 1934, at 49 Stat 3097 as supreme law of the land under Article 6, Clause 2. Now, what I'm going to do is I am going to upload this to, before I forget, to my page.
Awesome.
Anyways, Article 6, Clause 2 says, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. And that's like really important, okay? Anything in the Constitution or laws of any state to the contrary notwithstanding. That's Article 6, Clause 2. Because the U.S. Congress created the state of Texas, participated. So let me start that over again. Because the U.S. Congress created state of Texas, let's put a couple of commas there, I guess, participated in a walkout of Congress in 1861, Lincoln invoked the Insurrection Act, resulting in Texas being under a military occupation under martial law since 1861, when the U.S. Army invaded Galveston, Texas, as evidenced by General Orders 100, also known as the Lieber Code, which was written by Francis Lieber, our Harvard law professor, in 1863 as requested by Lincoln. So this is Article 1 of General Orders 100. Martial law is the immediate and direct effect and consequence of occupation or conquest. The presence of the hostile army proclaims its martial law. General Orders 100, the Lieber Code, has never been repealed and is now part of the United States Law of War Manual, a book about 4 inches thick. Under Article 2 of General Orders 100, the Lieber Code, martial law is and its military occupation continues to this day, because there was no treaty of peace, just an armistice, which is a ceasefire, and there's been no special proclamations by the commander-in-chief. Would be the President of the United States. Martial law does not cease during a hostile occupation except by special proclamation by the commander-in-chief or by special mention in the Treaty of Peace concluding the war. And so that's why you could do it with the Treaty of Hidalgo, because the Treaty of Hidalgo doesn't say anything. That's the treaty that was in the 1840s that brought in New Mexico, Arizona, California, Utah, Nevada, generally speaking, those territories into the U.S. The U.S. Army imposed a martial law military occupation on the territory properly included within and rightfully belonging to the Republic of Texas with their state of Texas military dictatorship. The martial law military occupation is illegal and unconstitutional under the 1933 Montevideo Convention on the Rights and Duties of States that was ratified as a treaty. And this is Article 11. The territory of a state is inviolable and may not be the object of a military occupation, nor of other measures of force imposed by another state directly or indirectly for any motive whatever, even temporarily. Which requires that the territory of a state is inviolable and may not be the object of a military occupation. The state of Texas is a military occupation put in place by the U.S. Army. It's impossible for a military dictatorship to be a Republican form of government. The United States shall guarantee to every state in this union a Republican form of government, as guaranteed by the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. That's Article 6, Clause 2 again. And also required by House Joint Resolution 1, dated 29 December 1845 at 9 Stat 108, right? So it said it had to have a Republican form of government. The fact that the Republic of Texas existed is beyond dispute. If there is no definition of how, and there is no definition of how many people are required to constitute a nation or state under Article 1 of the 1933 Montevideo Convention on the Rights and Duties of States, that was acceded to by the U.S. Senate as a treaty and entered into force December 26, 1934 at 49 Stat 3097 as the supreme law of the land. State as a person under international law should possess the following qualifications. 1, a permanent population, B, a defined territory, C, a government, and D, capacity to enter into relations with other states. That's all that's required. And all of the inhabitants of, quote, the territory properly included within and rightfully belonging to the Republic of Texas, unquote, are entitled to the same protection of the law. And this is the jurisdiction of states within the limits of the national territory applies to all the inhabitants. Nationals and foreigners are under the same protection of the law, and the national authorities and foreigners may not claim rights or other or more extensive than the nationals. It's Article 9. An unconstitutional law fails to be law. It imposes no duties. It offers no rights. It affords no protection. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. An unconstitutional act is not law. It confers no rights. It imposes no duties, affords no protection, creates no office. It's in legal contemplation as inoperative as though it had never been passed. An unconstitutional law is void and is as no law. An offense created by it is not a crime. Officers of the court have no immunity when violating a constitutional right, for they're deemed to know the law. The current Texas Constitution and all Texas statutes, codes, rules are edicts under martial law, as found in Article 3, General Orders 100, the Libra Code. Martial law in a hostile country consists in the suspension by the occupying military authority of the criminal and civil law and the domestic administration and government in the occupied place or territory, and in the substitution of military rule and force for the same, as well as the dictation of general laws as far as military necessity requires this suspension, substitution, or dictation. Dictation means dictatorship. The commander of the forces may proclaim that the administration of all civil and penal law shall continue either wholly or in part, as in times of peace, unless otherwise ordered by the military authority. So, again, it's at the pleasure of the military authority. So think about it. All Texas codes, rules, everything is edicts under martial law. Texas Constitution, statutes, codes, everything. And are therefore unconstitutional violation of the supreme law of the land. The military occupation might apply to government employees in the military, but there's no evidence introduced showing that the respondent is a government employee or in the military. The power to create presumptions is not a means of escape from constitutional restrictions. Therefore, this court is required to presume that no such evidence exists. If the record does not show upon its face the facts necessary to give jurisdiction, they'll presume not to have existed. The law requires proof of jurisdiction to appear on the record of the administrative agency in all administrative proceedings. The indictment, criminal complaints, warrants, etc., in cause number 1A47275 and 1900230 in the 45th District Court are all edicts under martial law and unconstitutional and illegal. The only thing the plaintiff needs to do is to allege false arrest. Is either A, that the defendant made the arrest or imprisonment, or 2, that the defendant affirmatively instigated, encouraged, incited, caused the arrest or imprisonment. And the court is required to presume it to be unlawful. When the plaintiff has shown he was arrested and imprisoned or restrained of his liberty by the defendant, the law presumes it to be unlawful. The burden is upon the defendant, the cop, to show that the arrest was made by authority of law. Any arrest made without a proper warrant signed by a judge and backed up by an affidavit from 2 persons that states under penalty of perjury you've broken a contract or hurt somebody, if challenged by the defendant, is presumptively invalid. The burden is upon the state to justify it as authorized by statute and does not violate constitutional provisions. As in the case of illegal arrest, the officer must keep within the law at his peril. Pursuant to the 1933 Montevideo Convention on the Rights and Duties of States, Article 11, which is the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. And the court has required it to be presumed to be unlawful. Pursuant to the 1933 Convention. Illegal searches and seizures, and this is another thing you can bring up. And a lot of people don't think of this. All information, okay, they got your name. How did they get that name? Well, they pulled it up from a government database, or they went and took it from your driver's license that they went and took from you under the force of a gun, right? Well, that's an illegal search and seizure. They didn't have a search warrant. Do you have a search warrant, officer? No, but I got this gun. All information, name, address, social security number, date of birth, etc., were obtained with illegal searches and seizure that of the respondent's information in government databases with no search warrants, as evidenced by the fact that no search warrants are in the evidence file. And the court is required to presume that no search warrants exist and suppress the evidence. Well, think about it. If they don't have your name, what do they got? They got an unknown individual. If they don't have your address, they have an unknown individual, and we don't know where he lives. You see what I'm saying? They don't have anything. If the record does not show upon its face the facts necessary to give jurisdiction or presumed not to have existed, the law requires proof of jurisdiction to appear on the record of the administrative agency. The common laws, the law of the land, was here before the government. This is Hale versus Henkel. His rights are such as existed by the law of the land long antecedent to the organization of the state and can only be taken from him by due process of law. If the military occupation is unconstitutional, it's a nullity, and everything reverts to common law, which is the law of the land, and was here before the government. And the respondent is not charged with any common law crimes. And the military charges have certainly nothing to do with common law. Therefore, it all needs to be dismissed. For all the foregoing reasons, the indictment, criminal complaints, all warrants, charges should be quashed. This case should be dismissed and the respondent released. So I haven't filed this into any cases yet. I filed a motion to quash, actually, into this particular case. And I don't know if again, I don't know if they've, the person is still in their jail. So, but there's supposed to be a hearing on Tuesday. So we'll see what happens at that hearing. But this is plan B, where I'm going to file this. The motion to quash didn't have near as much stuff in it as this does. This has quite a bit more. Anyways, and that's me, intervener, fails to be dead or lost at sea, has never been dead or lost at sea. This is standard stuff that I'm putting on all of my stuff now. Fails to be surety for the Pope's minor estate, fails to be representing the Pope's minor estate, has never willfully Pope's has never willfully represented the Pope's minor estate See, I've added in stuff, so now I got to bump the certificate of service down. So this is a total 10-page document with the certificate of service.
Awaiting Tuesday.
Sorry?
You're waiting for Tuesday.
Yeah, there's going to be a hearing on Tuesday.
Well, in that case, I hope you don't have to use it, but.
Well, hopefully they kick her out because of that that application or the motion to quash. I think there's enough stuff in there. The only stuff I didn't have in there was this stuff here: an unconstitutional law fails to be law, imposes no duties, offers no rights, affords no protection. And the reason that that's all like really good stuff because affords no protection is for judges, okay? Doesn't give them any immunity. If they go and try and enforce an unconstitutional law, then they have no immunity. You see what I'm saying? Affords no protection. And so that's basically, in a nice way, I'm telling the judge that you don't have any protection here. So I think this is I've added in this other stuff. This is all stuff that I added in, like even in the last day. The information thing. This is all stuff I used when I was in that jail in New Mexico, and I was actually it was when they brought me to Tarrant County. I was using it in there, and I would say. That's all hearsay, by the way. Is hearsay evidence was obtained with illegal search and seizure of the respondent's information in government databases with no search warrants, as evidenced by the fact that no search warrants are in the evidence file. Court is presumed that no search warrants exist and suppress the evidence. Yeah, I think that this is all. People need to bring this up. I've had other people contact me, and I went and emailed them this thing actually. Told them to use arguments out of here. They don't have to necessarily do it. This guy that emailed me was from Wisconsin. And so, proving Wisconsin's under a military occupation, well, you could make that allegation because they're all military police. And so you could say that there's a military occupation because the police are all military. You can do that. There's a bunch of stuff at the beginning, like if you're in California, you wouldn't need to bring in the stuff about the Republic of Texas. You could shrink it down, quite a bit. About the Texas joining the Confederacy and Union, you take all that stuff out. And then and so then the war between the states, you could the war with Mexico, right? Because of the war with Mexico, you'd have to describe it a little bit differently. And the fact that there's a Treaty of Hidalgo, but it doesn't say anything about the peace. You see what I'm saying? And so then everything else would apply. General Orders 100, no Treaty of Peace, martial law, military occupation, all of that stuff would apply. You could probably, how many pages is it up to here? 3. So you could knock off a couple pages out of this thing. And if you're in California, Arizona, Nevada, Utah, and half of New Mexico. Half of New Mexico is Texas, and so, but half of New Mexico is part of Treaty of Hidalgo territory. So, anyways, anybody could use it. Let's see. I'm going to save it, and then I'm going to upload it to my page. Well, let me do one thing. Let's do this.
What about case number or cause number?
It depends on the court. I mean, here in Texas, they call it a cause number, but you could.
Yeah, they use file here. File.
Yeah, yeah, it depends. Anyways, I'm gonna upload this now.
So the unlawful conversion that we were talking about earlier with some folks, in this case, it's in the name and through the unlawful warrant, right?
Right.
We talked about unlawful conversion, of how they're making us all wards of state.
Right.
So in this case, it would be how the warrant was handled and how the kidnapping took place.
Yep. But you got to build a case, and so what you do, that's where you do a. Matter of fact, I will. I'll upload another document that I sent. I think I already uploaded it. Let me look. Yeah, right. The FOIA. I already uploaded it. The FOIA for Jeremy Curtin. That's a FOIA that you send. At least in the U.S., you send it to the IRS, and it's a really good FOIA. We'll see what happens. I'm curious to see what the results of that is. I went and got my mail today, and there was nothing there. Well, there was nothing that I didn't expect to be there, and so there's nothing about this. And so I'm looking forward to seeing what comes in, but it's probably just barely got there, so I don't expect it to be coming back. It might be a week or so. Actually, they have like 21 days or something like that to respond, so it might be like next month sometime before I get a response. So I'm not expecting anything that quick. But I
Yeah,
uploaded the petition for writ of habeas corpus.
you made the corrections, right? Right.
Yep, yep.
We're waiting to hear about your friend then on Tuesday. That's
Yeah, yeah. Well, I'll report that next week if it had any effect. Oh, that was what I was going to do. What was I going to do? I was going to. Oh, that was it. The notice of intervention.
yes, to show how you have lawful authority, correct?
Well, it's just notifying them that I'm intervening on their behalf.
But don't you have to be granted or appointed by?
Nope, 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 nope.
Okay.
No, and see what I would do. I'm going to actually Holy cow, just a second here. I got to close some windows. There we go. Okay, let's do this. There. Okay, so this is the notice of intervention that I already filed. And what I would do is I would just I'd add that in there as a friend of the court. And so I'm interested in justice. I'm not interested in, well, as a friend of the court. You see what I'm saying? And so,
well, and you're going to show that it has public interest to correct the record, no?
Well, a friend of the court, that's what a friend of the court does. Is
okay, good.
You see what I'm saying? It's kind of like an amicus curiae. I went and talked about an amicus curiae on some of my other videos because I filed amicus curiae. Well, an amicus curiae is a friend of the court. Okay, so I'm coming in. I'm not representing anybody, so I'm not representing April. I'm not representing her. I'm just coming in as a friend of the court, and I want to present some law stuff that you need to be aware of. See what I'm saying? Anyways, so that's all it says right here. Sign and seal. That's it. And I can tell you that she's already she said that she talked to her lawyer, and they had some questions about some of the stuff I filed, which is, see, that's perfect. Because so they're recognizing it. Usually they don't. If I filed something on behalf of her, they wouldn't say a word about it because they wouldn't even recognize it. But they are recognizing my stuff that I filed. I filed a motion for 1099 copies, and the judge, what she got was the judge was not too happy about me wanting to get a hold of any tax information. Well, he's got no idea what's coming. Anyways, anyways, the bottom line though is that so they recognized it, and so we'll see what happens.
So they want to come to the table. Is that why the hearing was scheduled for Tuesday?
I don't know. She seemed to think that it was supposed to be a trial, but now she's saying that it looks like it's a bond reduction hearing, and they might release her on her own recognizance. And I'll bet you it's because I filed that motion to quash. I'll bet you that they're maybe even going to just dismiss the thing. I guess we'll see. But this is a notice intervention. No, but notice is hereby provided that I'm intervening on behalf of Republic of Texas National, April Rose Schoppel Lauritsen, as a friend of the court. That's it. That doesn't have to say much. It's a one-pager. And then there's a certificate of service. And I didn't send it to her liar because I didn't know who her liar was at the time. But and that's it. That's just a notice of intervention. And now I file other documents as intervener. See what I'm saying?
So does that attorney know what you filed, do you think? Or will they find out about it?
Well, the judge said something to him about it. So I think that
oh, yeah.
he knows now.
Yeah.
But I sent him a copy of the motion to quash. So, we'll see what happens there. That was mailed, but he should have it by now. It's been a week.
Interesting.
Yeah. So an intervener is a way better way of approaching it, in my opinion. Does anybody have any questions?
Yes, I've seen some approach the court as a friend of the court.
There you go. I filed a notice of appeal in my other case, too, by the way. The one they dismissed.
Well, spill it. No, I mean, can you go over that?
Sorry?
Are you able to go over that? Or
Well, it's just a one pager, but I'll open it up here and we can look at it if you want.
yeah, please.
Okay. Let me see here. The Court of Appeals hasn't responded at all. I actually had a friend of mine file it. I had him go down there and take it in and file it with the court. Um, it's short and sweet. I mean, there's nothing to it at all. Demandant hereby provides notice he intends to appeal the vexatious litigant findings and conclusions that fails to have anything to do with facts or law, and the dismissal of this matter by the military commissioners masquerading as judges in this legislative inferior court to the United States Court of Appeals for the Fifth Circuit. And that's it. That's it. I'm just giving them notice of appeal. 17th of February. And here is Ken took it in there and filed it. And that's it. That's it. There's a certificate of service. And what I'm
Well,
going to.
that's a heavy week, or I mean, very busy week for you.
Well,
Have you
this
got
one.
into any more? Sorry, go ahead. I was just going to ask if you got into any more of Todd Dewell's book.
Oh, actually, I've been getting into that. I didn't show that on here, did I? There. This is the notice of appeal. You guys didn't see it. It was shown on YouTube, but you guys didn't see it. So this is it. The I haven't been. I've been in that. I've been doing that killer court case manual. I find that way more interesting. Todd Dewell's stuff is good supporting stuff for that. But I think that killer court case book. I mean, that was a really good find there, Lori. Thank you very much. That's great stuff.
Yeah, I thank Colby for that. If there's any way that you can email Todd, I'm dying to ask him a question or get his rundown on something that he mentioned in, I think it was his last or latest release video. But he mentioned that the W4 process, which I have firsthand knowledge about. He said that it was not really useful in the court setting. Why did he say that? He said because it was only a auditing tool. Okay. And I'd love to ask him a question about that. Like, I know you're not familiar with the W4 process, but there are some in here that are familiar with it, and myself is included because I've filed a couple of them, and I'd love to be able to ask him questions about that. So if you said you got the book, you bought the book from them, is there like an open email that you get to ask questions to them about, or?
Well, the book doesn't even say it have his name in it. It's supposed to be. It's published by that Commoner Law Group, and it's supposed to be using his material, but they don't even have his name in it anywhere that I remember seeing. There's 5 of them, and but if you want, did you get the books?
No, I've only read the version that you put it out, but
So why
no.
don't you send me an email,
Mm-hmm.
and or maybe actually it'll be on WhatsApp. Maybe I can. I don't want to say what I'm going to do here in front of everybody. But
Mm-hmm.
send me I don't have any contact information, but I could probably um, I'll tell you what I'll do on WhatsApp.
Okay,
Okay.
fair enough.
Um, so a notice of appeal is pretty short and sweet. Nothing to it. And
You've
there's a
pumped up
certificate.
the signature there.
Sorry?
You've expressed everything in the signature there.
Yeah. Same stuff that I always put. I'm not a surety for the Pope's minor estate. I'm not representing the Pope's minor estate. I've never represented the Pope's minor estate. And notice I don't put without prejudice anywhere there. So, if nobody has any more questions, I guess that's about it for today. It's been going on for about 50 minutes, so let's see if there's anything on YouTube. It's on the somebody's asking for it. It's on the WeRLaw group on Telegram. If you contact me on Telegram, I can send you a link to join the WeRLaw group, and then you can find it on my page on the WeRLaw group on Telegram. Yeah, the files, the Word files. I don't usually upload PDFs. I mean, unless like there's the book, that court case killer book. Brennan, I think you'll be interested in that court case killer book, and I got that off the WeRLaw group too, but it is on my page. Um, so if there's anything else, then I suppose maybe we'll call it a day and wait till next week. Oh, what we're going to be doing tomorrow is we're going to be meeting with Kevin Annette. Does anybody know who Kevin Annette is?
Are you going to be talking with another Canuck? Oh my goodness. So what's Kevin up to? You should fill folks in as to who actually Kevin is. He's very, well, he's a hero Canadian in my view. So maybe you could let some folks know about what you're going to be doing with Kevin. It's awesome to hear.
We're going to meet with him tomorrow about possible grand jury for a criminal case against the state of Texas actors that we're having to deal with here in Texas.
Is he in Texas with you face to face or?
No, we'd be online.
Oh, okay. Good. Well, you'll have to let us know about that too next week because he's, I haven't heard anything from him in a long time. So he must be digging his heels into something pretty large because he works on large constitutional issues, doesn't he?
Well, he's got his international common law criminal court, and they actually held a trial for Donald Trump and the current Pope and all that, and convicted him. And so I'm not sure that I agree with the Donald Trump's conviction, but they did. They convicted him, and so I don't know. At any rate, the story is that from what I heard, is they convicted Pope Benedict. I don't know if you remember Pope Benedict Ratzinger. They convicted him of rape, child rape and murder, and stuff
Yes,
like
the
that.
cardinal is,
Yeah.
the cardinal is on the hot seat right now.
Well, so they convicted him, and when he was Pope, they went and sent the evidence that they had to Italian authorities. Not Italian, it was to Spanish authorities. And the Spanish authorities called him up and told him, don't come to Spain because if you do, you'll get arrested. And that's when he resigned. And remember, he's the one that resigned, and he spent the rest of his life in the Vatican. Because if he set foot outside of the Vatican, they would have arrested him. So, anyways, I think that they convicted that Bergoglio too. The current or the Francis Frank is friends of mine that didn't like him called him Frank. Anyways, they convicted Frank too, but he didn't leave office, so um, I don't know. I don't know. Sometimes it works and sometimes it doesn't. You know what I mean? I don't know. But anyway, so we're talking to him about putting these state of Texas actors on trial, and so we'll see what happens.
Many of the townships here are trying to petition for their mayors that are complying with the UN to be ousted out as well. So it's happening everywhere.
What did you say about Donald Trump getting indicted for what?
You'd have to go on that common law court, Kevin Annette's common law court website to see what it says there, because all I know is they convicted him of something. I'm not sure, and I kind of like Trump, so I don't want to say anything more than that. I would.
Yeah, and Glenn's going to be having a meeting with Kevin tomorrow, so we'll find out a little bit more. But it sounds like, well, I've heard just today that with what they're going or trying to do in Canada, they've reached out to the U.S. military for support. So I don't know how that's going to play out with them convicting Trump at the same time. So maybe ask Kevin about that, right? Because of the current situation, what they're trying to legislate in Canada, and I'm definitely not going to speak anything more about that, but maybe you should ask Kevin about some of those issues too, and how maybe we can do that here in Ottawa.
I don't know. Trump has his agenda. His primary focus, in my opinion, is to get honest elections and to get rid of the banksters. And that's where he's. I'm listening. I listen to a lot of 107, and that's what 107 talks about, and that's what I see Trump doing. I see him doing all of that stuff, and so I don't know as far as Canada, communist Canada. I don't know. I can tell you for sure if you go to that summons that Trump issued to call all the generals in, it said basically that we're going to separate ourselves from the British completely, from the British. And the British are the ones that are giving us all of this trouble. The British are the ones that Prince Andrew, the Epstein stuff, that was all a MI6 a honeypot operation, is what that was. And so they were Epstein went off the farm when he started getting juvenile girls and stuff like that involved, and then when they started having human sacrifices, I think that was beyond what most people could stomach, and that was one reason that it all fell apart. But at any rate, so at any rate, you know, all of that stuff is rumors. I don't know. I think that if anything, those Epstein stuff vindicates Trump. I don't think he was there, and he run Epstein off. Epstein was trying to hook up some of his employees at Mar-a-Lago, and he kicked him out of there. Get the hell out of here. So I like Trump, quite frankly, and so his primary objective is to get rid of the fake money, to get to lawful money, and to have honest elections. Homeland Security just raided Maricopa County too. I don't know if you know that or not, but they definitely raided Maricopa County and the election machines, and instead of fighting with them like they did in Georgia, they decided just to cooperate. And so I understand Kerry Lake is the governor of Arizona, and so we'll see. That's all I can say. It's all they have to build a case. The military does not want to get involved, but they're gonna, because they're gonna have to, because of the foreign interference, and that's going to there's going to be a bunch of arrests, and people are going to be taken to Guantanamo Bay, and it's going to be really, really ugly. And so um, we'll see. That's all I can say. I know that people have already been taken to Guantanamo Bay. These websites that talk about people being hung and stuff like that, I don't know that that's happening yet. I don't believe it is, because I think that in order for that kind of stuff, if someone gets hung, it's got to be public. Everybody's got to see it. People have to see that justice is done, and why it's done, and so there's websites going out peddling that stuff, and I think it's a bunch of crap, because people have to see it. It has to be public. People have to see that justice is done, and so there's a lot of disinformation out there. Anyways, I think we're about done for tonight, and so we'll meet next week, same time, same place, same channel. Thanks everybody for your attention, and we'll see you next week.
Yeah, have a good interview with Kevin tomorrow, and please update us on all those situations.
Okay, well, I might even record it. We'll see. If I do, I'll upload it to YouTube.
Awesome, that would be great. I would like to hear.
I've got some
But I
stuff
have a
on.
question.
What's that?
I have a question that Queen always asks everybody about grand juries, and if you would be prepared to sit on one of your obligations would be is to have somebody watch somebody be put to death. Would you be able to do that?
Well, grand juries, I don't think a grand jury does that. I've never heard of a grand jury does that. A grand jury is all they do is find probable cause. That's all a grand jury does. They just say whether there's probable cause of a crime. That's all. That's what an indictment is. An indictment is probable cause. So I've never heard of anything like that. It's watching someone being put to death. Hillary Clinton, I'd like to watch her get her neck stretched. Barack Obama, well, I don't think he's going to get his neck stretched. He's been a CIA tool from the day he was born. So I don't think that they'll stretch his neck because he's almost like he was born into that stuff, But there's people that I would like to see him get their neck stretched. That's but I don't think that grand juries have a duty to do that. I've never heard of that before. Anyways, we'll see you guys next week, same time, same place, same channel.
Absolutely. Don't be late.
All right. See ya.
See ya.